Welcome back to City Education, your home for education in all forms, shapes, and sizes. Today's topic takes us into the landmark judgment in Mahlangu versus Minister of Labor, a case that not only challenged domestic legislation, but also leaned on powerful regional human rights systems in order to secure one of South Africa's most vulnerable groups, domestic workers. But before we dive into the case, let's ask the question: what is the primary purpose of regional rights systems, like the African Charter and the SADC Charter? Well, these systems are designed to bridge the gap between international deals and local realities. They promote and protect rights through shared African values, harmonize laws across borders so that workers, migrants, and vulnerable groups enjoy protection no matter where they live, encourage governments to learn from each other and improve policy through regional dialogue, and give people, especially in countries with weak enforcement, additional avenue for justice beyond their national codes. In other words, the regional systems are like mirrors that reflect whether states are meeting their promises. And when those promises are broken, they offer a platform to call for change. In this video, we'll explore how the SADC Charter, the African Charter on Human and People's Rights, and the Maputo Protocol helped shape the court's decisions in Mahlangu, and why that matters for domestic workers, for equality, and for the future of human rights in South Africa. Let's begin. Now let's start with the facts behind Mahlangu versus Minister of Labor. Now Maria Mahlangu was a domestic worker in South Africa. For 22 years, she worked in a private home in Freeland, Pretoria. Like many other domestic workers, she was a breadwinner for her family, supporting her daughter, Sylvia. On the morning of 31 March 2012, tragedy struck. While Maria was cleaning her employer's home, Maria drowned in the employer's swimming pool. It was reported that she was partially blind and could not swim. Her death happened while she was performing her duties. After her mother's death, Sylvia Mahlangu turned to the Department of Labor. She hoped to claim for compensation under South Africa's Compensation for Occupational Injuries and Disease Act, commonly known as COIDA. But the department told her she couldn't claim anything. Why? Because COIDA excluded domestic workers from the definition of employee. This meant that Maria, despite working daily for decades, was invisible under the law. Sylvia's claim was rejected. No social security, no compensation, and no safety net. In response, Sylvia, with the support of the South African Domestic Service and Allied Workers Union, took the matter to court. She argued that this exclusion violated the right to equality, undermined human dignity, denied access to social security. And not only that, the case highlighted how the exclusion affected Black women disproportionately, showing the intersection of race, gender, and class discrimination. The matter eventually reached the Constitutional Court, South Africa's highest court on constitutional matters. The court also received input from two friends of the court, the Commission for Gender Equality and the Women's Legal Center Trust, both of whom argued that exclusion reinforced historic and structural injustices. The question before the court was simple but powerful. Can a law that excludes the most vulnerable groups of workers in South Africa be considered constitutional? When the Constitutional Court heard Mahlangu versus Minister of Labor, it wasn't just about compensation. It was about dignity, justice, and the human cost of exclusion. At the center of the case were three core constitutional rights, each of which is foundational to South Africa's democracy. First, Section 9, the rights to equality. This section says everyone is equal before the law and has the right to equal protection and benefit before the law. But why weren't domestic workers protected, while other workers in other fields who were injured or killed on the job could claim compensation? Was it simply because of the nature of their work and the location of their work in private homes? The court found that this was indirect discrimination on grounds of race, gender, and social origin, which are all protected under Section 9, subsection 3 of the Constitution. Most domestic workers in South Africa are Black, often working under insecure conditions and historically undervalued. The exclusion from the quarter simply perpetuated their structural disadvantage. The right is covered under Section 10, the right to human dignity. The Constitution declares that everyone has inherent dignity and the right to have their dignity respected and protected. The court recognized that excluded domestic workers, people who cared for homes, children, and elderly, sent a message that their lives and labor mattered less. Their dignity was undermined not only in life, but even in death, when compensation was denied to their families. The third section is Section 27, subsection 1, paragraph C, the right to access social security. According to this section, everyone has the right to have access to social security, including if they are unable to support themselves and their dependents. As we can see, domestic workers and their dependents like Sylvia Mahlangu were completely cut off from the social safety net. The only recourse which was afforded to them was to sue their employer under common law, which is slow, costly, and uncertain. The court said this violation not only infringed Section 27, but also the state's duty under Section 27, subsection 2, to take reasonable legislative steps to realize this right for everyone, including the most vulnerable. Inclusively, the Constitutional Court didn't analyze these rights in isolation. It used a holistic, intersectional lens, recognizing how race, gender, class, and labor status intersect to create systematic disadvantage. Under Section 39, subsection 1b, the court also considered international and regional human rights law to guide the interpretation of these rights, especially in the African Charter, the SADC Charter, and the Maputo Protocol. If the Mahlangu tourist were a story, paragraphs 36 and 45 are its emotional and legal climax. These 10 paragraphs are where Justice Victor exposes the structural injustice at the core of the exclusion and calls for a more just society. So what do they say? In paragraph 26, the court acknowledged the historical marginalization of domestic workers, mostly black and subjected to colonial and apartheid legacies, lack of recognition and legal protection, and the undervaluing of their essential labor in private house tools. The actual words sounded something like this: domestic workers have historically been treated as servants and have worked in private households for low wages and under conditions. Now, this is significant because it ties the exclusion from COIDA not just to oversight or policy, but rather to a pattern of systematic oppression based on race, gender, and economic class. The court affirms that the exclusion violates Section 9, the right to equality. This is covered under Sections 39 to 41. The key point was that this wasn't a neutral policy. It has disproportionate effects on a vulnerable group, even if the law doesn't explicitly mention race or gender. Paragraph 40 exclaimed that the exclusion of domestic workers from the definition of employees constitutes indirect discrimination that has a disproportionate impact on black women. This aligns with the concept of indirect discrimination, where a facially neutral law has unfair outcomes for historically disadvantaged groups. Now let's look at paragraphs 42 to 44. Here the court leans on international and regional human rights instruments to strengthen its constitutional analysis. It touched on the African Charter on Human and People's Rights, the SADC Charter on Fundamental Social Rights, and the Maputo Protocol on the rights of women in Africa. These instruments all recognize the right to equality, the protection of vulnerable workers, and the obligation to provide social security and the dignity for women in the labor force. The court reminds us that Section 39, subsection 1, paragraph B of the Constitution requires courts to consider international law when interpreting the Bill of Rights. Regional instruments are not optional. They are tools for deepening constitutional meaning. Now moving on to paragraphs 45 to 46, which were the final blow. In the final two paragraphs of this section, the court is direct. There is no justifiable reason to exclude domestic workers from the protections of the Code. The exclusion is irrational, unconstitutional, and must be removed. This was specifically paragraph 46 of the case. These words were powerful. They emphasized that the exclusion was not fair. It was not justified under the constitutional standards, and it was not included under the limitations clause of Section 36. The court further concluded that the state had no valid basis to continue denying domestic workers the protection given to others. This is transformative constitutionalism in action. After years of exclusion, a powerful truth was finally affirmed. Domestic workers are workers, and they deserve full constitutional protection. In Mahlangu versus Minister of Labor, the Constitutional Court declared the exclusion of domestic workers from COIDA unconstitutional. This was a unanimous decision, but the court didn't stop there. It ruled that the Declaration of Individuality would apply retrospectively from the 27th April 1994, which was the very start of South Africa's constitutional democracy. Now, what does this outcome mean in practice? It simply means that whether employed in private homes, farms, or small businesses, domestic workers are now fully protected under code. If they are injured or killed on the job, they and their dependents can claim compensation like any other employee. Derogatory relief means families like Sylvia McCarthy's, who were previously denied, may now receive justice and support. This remedy is exceptional. Courts are usually cautious about retrospective rulings. But in this case, the court recognized that to delay justice any further would entrench the very discrimination the Constitution seeks to undo. Now, the broader significance includes firstly, transformative constitutionalism in action. The ruling shows that South Africa's constitution isn't static, it's transformative. It demands the courts to dismantle historic exclusion and help build a society based on equality, dignity, and justice. The second significance is the recognition of intersectionality. The court used a multi-dimensional lens, acknowledging that Maria Mahlangu faced overlapping disadvantages, firstly as a black person, secondly as a woman, and thirdly as a low-income domestic worker. The intersectional approach recognizes that discrimination doesn't happen in solace, and justice must address the full reality of people's lives. The third significance is empowerment through regional law. The court cited the SADC Charter, African Charter, and Maputo Protocol, showing how African regional law strengthens domestic justice. This confirms that African solidarity in human rights is not just symbolic, it's legally effective. The fourth and final significance is precedent for future social economic rights cases. The Mahlangu case sets a high standard. It shows that statutes excluding informal and marginalized groups can and should be struck down. It also empowers advocates to rely on regional instruments to challenge unjust laws. In conclusion, the Mahlangu case is more than just a victory for domestic workers. It is a model of how South African courts can use regional human rights instruments to deepen constitutional interpretation, correct historical injustices, and affirm the dignity of the most vulnerable. That's the true power of African human rights systems in action. For more legal education content, subscribe to City Education. Don't forget to like, share, and subscribe. Oh, and feel free to turn on your notification as well.